works. Somebody gets arrested, they arraign them, the guy has to plead. Usually he'll plead not guilty, no matter what, even if it's fairly obvious that he is guilty. He'll plead not guilty because they have to prove that he is guilty, if he pleads not guilty. Then the judge has to decide what to do with the guy. Is he going to leave him in prison, or is he going to allow him to make bail? Judges must decide whether to keep criminal defendants in custody between arrest and trial, or whether to release them with a promise to reappear for later hearings. They can deny bail if the defendant is a flight risk. They're afraid that they won't show up at a trial. They can require that money be deposited with the court. They will usually use a bail bondsman for that. They can require that a third person be responsible for the defendant's future appearances. Usually this individual will forfeit money if the defendant doesn't appear. So they can either deny bail, they can have them pay the court money. Hey, Joe.
Take my hat.
Did they win? Are they in the World Series?
Yeah.
They were playing against Milwaukee, I think. They went to a 7th game. I didn't notice. Or they can have they can require that a third person vouch for them. In addition to ensuring the defendant's return to court, bail has a secondary purpose. It protects their safety because if they deny bail, then of course they're saying that this person's too dangerous to function outside of the prison system. Bail decisions are influenced by both legal factors like the seriousness of the offense and extra legal factors. And this has to do with race and gender, strangely enough. So who's the most dangerous person, males or females? Who's more dangerous, boys or girls? Males? Okay. So if it's a female, then they're more likely to get bail, as odd as that may seem. How about race? Why would race come into anything? Why should they care whether the person is black, Hispanic, Asian, or indigenous, or whatever, or white? Why would race have anything to do with anything? Remember, we live in the United States. The United States has this odd stereotype that black males are the most dangerous creatures on earth, as odd as that may seem. If we watch the news, we know who is actually the most dangerous people in the world. What race was the guy that shot up Las Vegas? What race was he? He was white? Okay, I was just curious. How about the guy that shot up Lakeland, the school at Lakeland? Not Lakeland, it was Parkland, I'm sorry, Parkland in Florida. What race was that guy? Well, his last name was Cruz, but he was actually white. He wasn't Hispanic at all, as odd as that may seem. How about Klebold and Harris? What was he? What were they? Were they the same race? Is this important? Well, it is if you're profiling people. It's real important. Well, how about Klebold and Harris? What were they? White. Okay, what about the guy that shot up the theater in Aurora, Colorado? What color was his hair? He dyed it red. Was he? What race was he?
White.
Again? So the most dangerous people in the world seem to be white people. They seem to shoot a lot of people, don't they? They seem to, anyway. So the most dangerous person in this room is me. It's despite the fact that Joe's not supposed to be here and he's here anyway, he's not the most dangerous guy in the room. It's me because I'm a white guy. Now, in the old days, we would have thought, geez, that guy's older than dirt. He can probably barely lift a rifle. I'm almost 70 years old, so I shouldn't be that dangerous. But then the guy that shot up Las Vegas is 64 years old. So white people get pissed, and when they get pissed, they pick up guns and start shooting people. Well, it seems to be the way it works. So the most dangerous people on the planet, or at least in the United States, seem to be white people. So does race have anything to do with it? Yeah, so white people are the ones that are more likely to pick up a gun and start shooting people, but how about bail? Do they get bail more often than black people or Hispanics? And the answer is yeah. Well, that doesn't make any sense. That's backwards, isn't it? They need to take my class. Those judges need to take my class. Legal factors, research has shown that bail is likely to be denied or set very high when the offense was serious and when the defendant has prior convictions. Race and gender has been shown to have significant impacts on judges' pretrial release decisions. For example, black defendants were less likely than other defendants to be released, and female defendants were assigned lower bail amounts than males. So no matter what she did, she usually gets bail. The one case that I can think of where the lady didn't get bail was Andrea Yates, who drowned her 5 children. One of them was an infant. Judges tend to use a mental shortcut called the matching heuristic when determining whether bail should be allowed. They search through a subset of available case information and then make a decision on the basis of only a small number of factors. Usually it has to do with, normally it has to do with offense severity. So if it's a murder case, they probably will not allow the individual to get out on bail. And their prior record, have they done this before? They usually ignore everything else unless it is relevant information. And of course, the prosecuting attorney will make a recommendation. But it's the judge that decides whether they get to have bail or not. Does pretrial release affect trial outcome? Yes. Defendants who are detained in a jail are more likely to plead guilty or be convicted and receive longer sentences than those who can afford bail, even when the seriousness of their offenses and evidence against them are the same. Okay, so what does that mean? Who's getting bail and who's not getting bail? Well, women get bail and white people get bail. So white people are less likely to be convicted than other individuals. And that may be one of the reasons why our prisons are full of African Americans and Hispanics and indigenous peoples. Around 1970, a push began for legislation that would increase the use of preventative detention, the detention of accused persons who pose a risk or flight or dangerousness. This assumes that valid assessments of risk and accurate predictions of future dangerous conduct can be made, an assumption that is not always correct. We don't know what this person's going to do. We have no idea. But, of course, if we allow them to go out on bail and they commit another crime, now it made us look really, really stupid. So the reality is you can't identify high-risk defendants. Most criminal cases, from 90 to 95%, end prior to trial with plea bargaining. This is one of the reasons that lawyers actually very rarely go to court. Well, they do go to court, but only in the preliminary portion. They rarely go to trial. It is relatively rare. So if you've got a lawyer, he may never have gone to court. He may have 20, 30 years of experience and never have gone to trial because they plea bargain. 90 to 95%. The defendant pleads guilty to some charge in exchange for some concession from the prosecutor. Usually it's a reduction of the type of charge. As I told you, a lot of times they will charge the individual with lots of crimes, as many as they can possibly think of. So they don't just get you for speeding, they get you for operating a motor vehicle in a dangerous manner. So they get you on as many charges as they possibly can get you for. They used to do this in the military, as I told you before. If somebody is caught in flagrante delicto while having sex, they'll try to charge them with as many things as they possibly can. And the reason they do that is so that they, if they have to plea bargain, they can plea bargain down. They may get adultery, they may have sodomy, they may have fornication. There's just a number of things that don't actually exist in the civilian community. They'll just charge them with a bunch of things, and then they will actually convict them on lesser charges because they plea bargain. One of the reasons that that court-martials are very rare is because normally they plea bargain and they don't. The commander gets to decide what the punishment's going to be. And it's the same way in the civilian community. Most people plea bargain. So they will, if they charge somebody with rape and assault and a lot of times you can't prove rape. You can prove assault, but you can't prove rape. It's one of the reasons why so few rapists actually go to prison. They will plea bargain down to a common assault charge. And they'll spend 6 months in jail or whatever. Whereas if they could actually prove the rape, they could put him in jail for an extended length of time. In charge bargaining, the prosecutor drops some charges in return for a guilty plea. Prosecutors often overcharge to be in a good position for this, and that's what I was just talking about, overcharging. Plea bargaining may also take the form of sentence bargaining in which prosecutors recommend reduced sentences in return for a guilty plea. In general, judges will follow the sentences recommended by the prosecutors, but they don't have to. Once somebody is going to court, Manafort is going to court in October. He's actually been charged with 2 different sets of crimes. One set is a Virginia crime and the other is a federal crime. He has gone to Virginia court and they charged him with 18 counts of fraud or whatever they charged him with, and he was convicted on 8 of them. So now he's going to go he has to go to his sentencing. So the prosecutor, they made a deal. He made a deal with the federal prosecutors, and he is whatever his deal was. The judge doesn't have to accept it. So this is really going to be interesting to see what happens next, as far as Paul Manafort is concerned. He has agreed to testify or to give evidence against whatever, as far as with Mueller. So we'll see what happens as far as he's concerned. They're going to send him to prison, obviously. He's been charged with 8 counts of fraud and income tax evasion. So we'll see how long he gets to spend in jail. But he has plea bargained and he has agreed to work with the federal prosecutor. So we'll see what happens. Could be interesting. He could go to jail for an extended length of time. If he hadn't agreed to work with Mueller, then he probably would have gone to jail for an extended length of time. But part of the deal may be that he has a reduced sentence. He's kind of old. He's in his 70s, so we'll see what happens. Why do defendants plead guilty? Because the likelihood of conviction is high. Because if convicted, they would face lengthy sentences in jail. And this is the reason why they plead guilty. Why do prosecutors plea bargain? To dispose of cases in which the evidence against the defendant is weak, where the defense attorney is a formidable foe. Actually, the person that you hire is very important. If the person that you hire is known, and they're a good defense attorney, they'll come up with any way to get the individual off. And sometimes the prosecuting attorney doesn't want to lose cases. He has to be elected. And the fewer cases that he has lost, the more likely that he will be elected in the next election. So it may be that the defense attorney is a formidable foe, and for that reason they don't want to go to court, because they're afraid they're going to lose. And of course they will ensure a win if they plea bargain, then it is a win. And of course, to obtain the testimony of one defendant against a more culpable defendant, I told you the story of my second cousin who murdered the guy. Actually, it was the other guy that murdered him, but the first guy went to court. He was 18. He was already 18, so they could extradite him. But my cousin was only 16 when it happened, so they couldn't extradite him as a minor. And of course, the idiot went back to Indiana and got arrested when he turned 18. So they arrested him, and then they took him to court. The other guy had already dropped a dime on him. The other guy had already gone to court. He went to jail for about 5 years. My cousin went to jail for life, what was supposed to be life. They let him out in his 30s. I find that he got out, but it was the other guy that actually committed the crime. It was my cousin's idea to put him in the trunk and sink the car. What an idiot. Anyway, so he was the one who was charged with murder. The other guy was charged with manslaughter or something. Anyway. So they were able to get the first guy to testify against my cousin. And for that reason, he went to jail. People in my family are kind of stupid. Have I told you that? They think that everybody's going to be honest, that if they don't tell on somebody, nobody's going to tell on them, because, you know, they have this, they're just dumb as dirt. Anyway, so he went to jail for, I don't know, 15 or 16 years. To expedite the flow of cases, of course, there is a backlog of cases, criminal cases in the courts. And this can be a problem. Shane Guthrie was 24 years old. He was arrested in Gainesville, Florida in 2010, charged with aggravated battery and false imprisonment on his pregnant girlfriend. She wanted to leave. She didn't want to be his girlfriend anymore. She wanted to take off. She was afraid he was going to be abusive to the child. Guthrie was initially offered a plea deal of 2 years in prison and probation, which Guthrie refused because he thought he had every right in the world to want to keep his baby, even though she hadn't given birth yet. The prosecutor then offered him 5 years, and he declined. So they offered him 2 years. The plea deal was 2 years, then it was 5 years, and I have no idea why they had that circle down there. The prosecutor couldn't get Guthrie to plead guilty, so a year later he filed first-degree felony kidnapping charges, which has a life imprisonment if he is convicted. He went from 2 years in prison to 50 years in prison because he couldn't take the plea deal, or he wouldn't take the plea deal. So sometimes pleading down is not a bad thing. It's a good thing. I have no idea. Okay, maybe she's giving birth. I don't know. Framing effects, the way decision alternatives are framed, gains or losses can have an impact on a person's choice. Individuals are more willing to take chances when the decision alternatives are presented in terms of gains rather than terms of losses. So you accentuate the positive and you forget about the negatives. So that's how you present these things to someone who you're trying to bargain with. Overconfidence bias, people tend to be too optimistic about their chances of securing favorable outcomes. So usually it's the second time that you try to plea down a defendant that you get them to agree to it, not the first time. First time they usually say no because they think everything's going to be better. And then the lawyer starts talking to them, and the lawyer convinces them that they're going to go to jail for a select amount of time, potentially if you are convicted and I do a poor job with the judge, then potentially you'll go to jail for 30 years or 40 years. And then they come back with a plea deal of 5 years. And they agree to that. They agree to the 5 years. first deal they usually reject. Advocates cite the following justifications for plea bargaining. Guilty pleas relieve the backlog of cases, and this is, of course, is a really serious problem. Remember, 90 to 95% of all cases are plead down. They never go to court. They never go to trial. Facilitate the prosecution of other offenders. If there are 3 people that robbed a bank, then they try to get at least one of them to turn so that they can throw the book at the other 2. So the question is, who's going to crack first? I keep talking about the lady that she was a crackhead, and they arrested her. They arrested her for forging checks. Is what they arrested her for. But of course, they knew that she was a crackhead. They knew that she was using, and they tried to get her to turn on her supplier, who turned out to be her boyfriend. As interesting as that was. And of course, she wouldn't flip on him, so she went to jail. And they told her, you know, if you plead down, if you give us your supplier, then we'll only give you 6 months, and we'll clean you up while you're in prison. And she wouldn't do it. She wouldn't drop a dime on the guy. So she went to jail. She went to jail for 18 months. For forging checks, which was right at the end. The max was 2 years, I think, and she went to jail for 18 months. And so, of course, why did she do it? Why didn't she drop a dime on her boyfriend? Remember, we were talking about love before. Okay. Well, she was in love with the guy. Well, guess what happened when she got out of jail? Yeah, he was already, he was shacked up with at least one other person. And of course, he never came to visit her in prison. Of course, she could have turned on him at any time, but he didn't, at least he wasn't shacked up with anybody while she was in prison. Anyway, she never dropped a dime on the guy. Funny lady. The absence of a trial reduces the involvement of various criminal justice personnel. So judges do get involved, but it's only in a tertiary manner. Of course, if it goes to trial, then they become very important. Prosecuting attorneys, usually this has to do with prosecuting attorney. He's the one that you're making deals with, that the judges are making or that the defense attorney is making deals with. And this is one of the reasons that defense attorneys, why they get paid as much money as they get paid, because here they are, they're talking to the prosecuting attorney and trying to plea down the whole situation. Now, the deal on the reservation is so much different than it is off the reservation, because off the reservation, you're dealing with the state, you're dealing with the county. On the reservation, you're dealing with federal prosecutors. Federal prosecutors tend to be a little bit more, what's the word I'm looking for? Can I use the word mean? Yeah, that fits. So you're dealing with a whole different kettle of fish. And for that reason, a lot of people go to prison. Because they don't plea, and there is no parole as far as federal prison is concerned. It just doesn't work that way. But in the state, my goodness, they were housing their prisoners in a tent city in Phoenix, right outside of Phoenix. They were just paroling people by the masses because they had too many prisoners and they didn't have enough jail space. They were shipping the people north. They were shipping them to Missouri. They were shipping them to Iowa and Illinois. They were opening all these prisons, and they were sending the people prosecuted in Arizona away from the heat, I guess, for one thing. So if you go to federal prison, there is a federal prison in Arizona, but you may have to go to Missouri. You may have to go to Fort Leavenworth in order to go to prison, especially if it's a serious crime. So a lot of times when people are tried in federal court, they go to jail way far away Way, way far away. Critics cite the following justifications for plea bargaining. Improper sentences, sometimes too harsh, but more often too lenient, are likely. The process encourages defendants to surrender their constitutional rights. So the reality is, if you are charged with a felony, then you don't get to vote. There are select things that you don't get to do anymore because you're a felon. Some states have allowed felons to vote, but most states do not. So if you are charged with a felony, then you will never vote again. Potentially you'll never vote again unless you're exonerated at some point. Or if most governors can sign off and allow you to vote in the future, but it doesn't happen very often. Prosecutors exert too much power, and that is true. They do exert a lot of power. Innocent defendants might feel coerced to plead guilty, and that is, of course, a problem. I remember the rape case we were talking about earlier. The individual was eventually exonerated after 30 years in prison, but he was convicted, and he was sent to jail for 30 years. And they couldn't coerce him into pleading guilty, but he was convicted anyway. The vast majority of civil disputes are resolved without a trial, and for example, settlement negotiation, this is known as settlement negotiation, typically in private negotiations between attorneys representing the disputing parties. And of course, we're going to talk about divorce at some juncture in one of these chapters. This is normally the way it's done in a divorce case, if it's a conflictual divorce. The legal merits of the case matter most. Outcomes are also influenced by the negotiator's reservation price. The defendant's reservation price is the maximum amount of money that he or she would be willing to pay to reach an agreement. The plaintiff's reservation price is the minimum amount of money that he or she would accept to settle the claim. So when we're talking about cases against Trump and the Trump organization, a lot of times he claims that he won this case. Well, it has to do with settlement negotiation. It has to do with his reservation price and the other individual's reservation price. So he may have agreed to pay, $1 million for marble fixtures in a building, and then when it came time to pay, he didn't pay. So the guy sued him in court, and of course they were threatening to go to trial, and usually they plea bargain. And normally what happened was, okay, I wanted to charge you $1 million for all that marble, but I am willing to accept $750,000. And so Trump says no, or his lawyers say. Of course, he doesn't really have that much to do with it. So his lawyers say, well, we'll pay you $500,000. And they say, well, that doesn't even pay for the labor to put all this marble in. And they say, well, you're willing to take $750,000. I'll tell you what, we'll give you $675,000, and that will pay your labor costs, and that will pay your legal fees. And so then they will accept it, because otherwise they get nothing. Or they'll go to court, and potentially, it all depends on whether the judge is friendly or unfriendly as to whether they get any money at all. So that's the way it normally works. Everybody has a maximum price and a minimum price that they will accept. And that's one of the reasons why he claims that he has never lost in court. And the reality is he just usually plea bargains. And that's why he's never lost in court. In considering the merits of a case, plaintiffs, defendants, and attorneys are influenced by heuristics, psychological biases. The self-serving bias occurs when people interpret information or make decisions in ways that are consistent with their own interests rather than an objective fashion. Parties often have difficulty seeing merits of the other side. We're talking about the case of the marble fixtures in a Trump tower, in a Trump building. He thinks that it's worth, he agreed in the beginning to pay $1 million for the marble, but then he realized that the marble wasn't thick enough, or it wasn't what he was thinking, it was the wrong color. So he doesn't want it, or he doesn't want to pay as much money as he said he was going to pay. It's not perfect. And of course, the person that put it in, they worked their tails off trying to put this thing in. And neither side sees the other side's merit. So the person that puts the marble in doesn't recognize the fact that it's not exactly what he wanted. And of course, Trump doesn't see the fact that he's never had to put in marble. He's never done anything. He's never lifted a hammer, so he doesn't understand how difficult it is to put this stuff in. So neither side sees the merit of the other side. The anchoring and adjustment bias occurs when negotiators are strongly influenced or anchored by an initial starting value and do not sufficiently adjust their judgments away from the starting point. The higher the first offer, the higher the ultimate settlement. That's usually the way it works. Okay, so the jury, so it goes to trial, and the jury awards somebody, damages, and they award millions and millions of dollars. Do they ever have to pay the $52 million? That's the record so far. Awards of $52 million. Will they ever pay $52 million? As a plaintiff, Johnny. As the plaintiff, will I get $52 million? The settlement's $52 million. Am I ever going to get my $52 million? No, of course I'm not going to get $52 million. First of all, I have to pay the lawyers, and the lawyers take how much? I think it's a third. I think it's a third. So yeah, I'm not going to get $52 million. Depending on how many lawyers there are. Sometimes you're getting pennies on the dollar, and that's the way it works. But the lawyers always get their money, and their money always comes off the top. So that's kind of strange. Or not. I guess if you're a lawyer, it doesn't seem strange. Miller and Boaster in 1977 have identified 3 images of the trial. The trial is a search for the truth. Is that the way it works? Is that what was going on with Kavanaugh? Were we looking for the truth in the Kavanaugh situation, the Kavanaugh hearings? Were they looking for the truth? Well, proof rather than truth. And there was no proof. Yeah, there was no proof to be had. I mean, it was a 35-year-old case. So what was the probability that they would be able to do it? What's the probability? Do you remember what you were doing 35 years ago? First of all, you got to remember what year that was. 35 years ago. So this is 2018. 83? Well, most of you weren't even alive 35 years ago. But I'm older than that, and so what year was it, 83? Okay. First of all, I have to remember where I was. Okay. In 82, I was in Germany, and we came back to the States, and we were stationed at Offutt. So in 83, I was still in the military until September. Okay, so do I remember a party that I went to? Actually, I don't go to parties, so that's why my wives have said I'm the most boring person in the world. Okay. So can you remember 83 years ago? I mean, 1983? Can you remember 35 years ago? I can remember where I was, but I can't remember a specific party. Okay. No wonder Kavanaugh can't remember trying to molest the young lady. So are we looking for the truth? Well, that's one of the reasons why we had the trial. It assumes that truth can be ascertained and that it will emerge from the confrontation of conflicting facts. It also assumes that judges or jurors can put aside the prejudices and decide the case with a dispassionate analysis of the arguments and evidence. It can be difficult to meet this ideal, of course. If the Kavanaugh situation had gone to court, would they convict him of sexual molestation? It was 35 years ago. First of all, the statute of limitations has run out on sexual assault in Maryland. But could they have convicted him if it had gone to court? All the lawyers who looked at the case, even if they believed Christine Blasey Ford, they said they wouldn't have been able to prosecute. There wasn't enough evidence to prosecute. And people are still upset about it. I mean, McConnell was screamed at in a restaurant over the weekend. The guy called him a disgrace. He said he didn't deserve to eat out in public. I don't know. Anyway, this was in Louisville. So they said they couldn't prosecute, and nobody has said that he should go to jail. But we'll see what kind of a judge he is. He doesn't like you guys. I'm sorry. He does not like indigenous people. He doesn't.
You can return the favor.
He doesn't like minorities. I'm sorry.
Yeah. I was like, you can return the favor.
Yeah, you don't have to like him either. Yeah, it should be interesting to watch him in the court. The trial is a test of credibility. That's the second thing that the trial is. Acknowledgements that facts and evidence are incomplete and biased. Judge or jury must weigh and evaluate the truthfulness of the opposing sources. Unfortunately, both judges and jurors can make unwarranted inferences, and of course that's one of the things that Bull does. That's one of the things that Phil McGraw used to do, Dr. Phil. The trial is a conflict resolving ritual. It provides a mechanism to resolve controversies, to create the sense that justice is being done. And of course, sometimes justice is not being done. Steps in the trial. The first thing is preliminary actions. Discovery, the pretrial process by which each side tries to gain vital information, such as the police records, about the case that will be presented by the other side. And of course, they're both looking for the evidence that is going to either convict or allow this individual to walk. The preliminary actions, the first thing they do is they draw a panel of prospective jurors. This is called venire. I can't even, it's Italian. It's actually Latin. From a large list, usually it's a large list of individuals. Usually it's based on voter registration lists and lists of licensed drivers. I've never been on a jury. I've never been any place long enough to be on a jury. My brother was on a jury once, and he'll never be on a jury again because it looked like he was just some guy off the street, but he actually tried the case himself. He didn't think the judge did a very good job, and he didn't think the two attorneys did a very good job. So, and they can do this. I mean, an impaneled jury can retry the case if they want to. They are 12 men tried and true, or 12 individuals tried and true. And he did. He actually retried the case in the jury room, and they allowed the guy to walk. Once the venire for a trial has been selected, a process known as voir dire is employed to question and select the eventual jurors. And that's when they ask them questions. If you've ever watched Bull, they ask them really interesting questions to find out how they feel about the type of crime that has been committed. Then the trial starts. We have impaneled a jury. The jury will, sometimes the jury is cloistered. In other words, they're not allowed to read newspapers, watch television. They are put in separate rooms so that they can't talk to each other, and then they just hear the case. They're paid a minimum amount of money. They're paid like $25 a day or whatever it is. Not exactly sure what is going on now. It's not very much money. So if you work at a job, of course you're not being paid while you're on the jury by your job, and the state is actually paying you. And sometimes these trials can go on for months. So the first thing that happens in the trial is the opening statements. Lawyers for each side are permitted to make opening statements. They don't present evidence. It's just kind of an overview of what they're going to see. So the prosecuting attorney normally goes first, and the defense attorney goes second with his opening statements. But he doesn't have to make an opening statement. He can wait until he presents his evidence. So the prosecuting attorney goes first, and the defense attorney goes second if he chooses to. After opening statements, the prosecution or the plaintiff calls its witnesses. Each witness testifies under oath with the threat of a charge of perjury if the witness fails to be truthful. And this is one of the things that happened in the Kavanaugh case. They actually didn't. Kavanaugh was under oath, but they tried to put Judge, was the other guy, that theoretically was in the room when the assault took place, but they couldn't get him to testify under oath, which was kind of interesting. She testified, she not only testified under oath, but she also took a lie detector test. And of course she passed the lie detector test, which was kind of interesting. So if they lie, then they perjure themselves. Okay, so what if Judge had said, yeah, we did it? What would have happened next if he had admitted that he did it? Of course, it was 35 years ago. What was another problem that judges had over the last 35 years? He's an alcoholic and he's been a drug user. So the probability that he has memory from the last week is fairly remote, let alone 35 years ago. And of course, she was 15 years old. They were 17. Judge was 18 and Kavanaugh was 17. So actually, Kavanaugh couldn't have been charged with a crime anyway. He was too young. He would have to have been charged as a juvenile. But Judge, of course, was an adult. So if Judge had actually testified that he did it, then he could have been arrested, even though statute of limitations has run out. Well, maybe not. Each witness undergoes direct examination, cross-examination, redirect, and recross. So they get to question him 3 times. We're talking about the prosecuting attorney. So he gets the direct examination, tries to get the information he's looking for. The defense attorney cross-examines, tries to refute the things that he has said, or she has said, whichever. And then the prosecuting attorney gets to talk to him again. And this is known as redirect. And if he says anything controversial in the redirect, then the defense attorney gets to recross. In other words, he gets to talk to him again. So potentially he gets to be talked to 4 times. Twice by the prosecuting attorney and twice by the defense attorney. After the prosecution's or the plaintiff's attorneys have presented all their witnesses, it is the defense's turn. Each witness undergoes direct examination, cross-examination, redirect, and recross. Once again, they get to be questioned 4 times, twice by the prosecuting attorney and twice by the defense attorney. After both sides have presented their witnesses, one or both may decide to ask the judge for permission to present rebuttal evidence, which attempts to counteract or disprove evidence given by an earlier witness. So we've had the prosecution has presented their evidence, the defense has entered their evidence, and then we have the rebuttal evidence. So we have 3 different sets of evidences that are coming in to the trial. Once all the evidence has been presented, each side is permitted to make a closing argument, also known as a summation. Typically the prosecution or the plaintiff gets the first summation, followed by the defense, after which the prosecution or plaintiff responds. In other words, the prosecution gets to talk first, the defense gets to talk second, and then the prosecution gets to refute what the defense has said. So the prosecution actually gets to sum up his case twice, but the defense only gets once. The final step in the jury trial is for the judge to give instructions to the jury. In some states, instructions precede the closing arguments. The judge informs the jury of the relevant law and what the law states and how, well, actually they don't talk about sentencing, not quite yet. The judge also instructs jurors about the standard they should use to weigh the evidence. With criminal charges, the jurors must be convinced beyond a reasonable doubt that the defendant is guilty before they vote to convict. In the civil trial, the preponderance of the evidence is necessary for finding in favor of one side. So there must be a preponderance of evidence. In the O.J. case, if you remember, it was a criminal case. He was acquitted, and then it went to civil court, and he lost in civil court. In other words, they thought that there was a preponderance of evidence that he had actually murdered his ex-wife and Ronald Goldman. That's what happened in the civil court. The criminal case, he did not have to go to prison as a criminal. Now, in a civil case, they can't. Nobody goes to jail in a civil case. That's not the reason for a civil case. That's a criminal case. So he didn't have to go to jail, even though he lost the case. What he had to do was pay damages. And of course, they charged him, I don't know, really a large amount of money, to the extent that he had to sell his Heisman Trophy. He had to auction it off. And all the money that he made from then on, he had to pay to to Ronald Goldman's parents, as it turned out. It was Ronald Goldman's parents are the ones that brought the civil case, the civil suit against him, and he lost. When the jury has reached its verdict, it's a four-person. It forms the bailiff, who informs the judge, who reconvenes the attorneys and defendants and plaintiffs in a civil trial for announcement of the verdict. So now we're going to disclose what the verdict is. Usually, if we look at a trial, it seems like the prosecution has an advantage. They do have an advantage. They get to sum up twice, and the defense only gets to sum up one time. They also get to rebut the evidence presented by the defense. Of course, the defense can rebut the evidence of the prosecution as well. But it seems like they get to talk a lot more than the defense attorneys get to talk. The prosecution is first to address the judge or jury. It has the full resources of the government behind it, theoretically, if the government has any money. The prosecution presents its evidence before the defense. At the end of the trial, the prosecution gets to go first and also gets the chance to offer a final rebuttal to the defense's closing argument. So it seems like the prosecution has an advantage in courts. So what if the prosecution, what if it's a poor guy that is on trial? Remember, the prosecution has all the money in the government behind it. What if it's somebody that's poor? What if it's somebody that's rich? They can pay for just about anything they want. So rich people seem to have an advantage in a court of law. That doesn't seem fair, does it? I mean, everybody has to have a lawyer. But they don't have to have a good lawyer. But a rich person can hire the best lawyer out there. A lawyer that people are afraid of because he never loses or she never loses, whichever the case may be. So if you're wealthy, you've got an advantage over poor people. A poor defendant. If you're a wealthy defendant, you're less likely to be convicted. Does that make sense? Okay. So rich people have an advantage. And the prosecution has an advantage because they have all the money that the government can afford. Advantages to the defense does not bear the burden of proof. In other words, the prosecution has to prove that this guy actually committed the crime. So the defense doesn't have to do anything. They can just sit there and not do jack. And if the prosecution doesn't prove that the individual committed a crime, And usually that's the first thing that they say. The prosecution will present their evidence, and the first thing the defense attorney will say is, I think we need to, they didn't prove that he committed the crime. I think we should stop the trial right here. And a lot of times that's exactly what happens if the prosecution has not presented enough evidence. The prosecution must turn over exculpatory evidence. This is in discovery. So if there is any evidence that shows that their client didn't commit the crime, they have to give it to them. They can't hold it back. So the defense does have an advantage to some extent, because if there's any evidence out there that he didn't commit the crime, there's a footprint in the mud that is too big for this person's foot, or it's too small for this person's foot, or it's a female defendant and it's a male's shoe, that's exculpatory evidence. It shows that somebody else might have committed the crime. And remember, they don't have the burden of proof. They don't have to prove anything. All they have to prove is that the prosecution's case is not adequate. The defense may have more opportunities than the prosecution to remove potential jurors without giving a reason. Defendants do not have to take the stand as witnesses on their own behalf. Defendants who are found not guilty can never be tried again for that specific crime. That's known as double jeopardy, and of course that is illegal. So if somebody is acquitted, even if later on they say, yeah, I did it. You know, I shot him right in the head. I didn't, you know. If they've been to court and they've been acquitted, there's nothing anybody can do about it. And of course, they don't have to take the stand. The defendant doesn't have to take the stand. And this seems to be what's happening now. If we have a court, well, Manafort didn't take the stand in his own defense. You don't have to testify in your own behalf. And that seems to be what's happening in defense in criminal cases these days. If the defendant in a criminal trial is judged guilty, a punishment must be decided. In most jurisdictions, the trial judge decides the punishment. But in some jurisdictions, it's the jurors that award the punishment. 2004 decision, the United States Supreme Court ruled the judges may not increase defendants' sentences on the basis of what they perceive as aggravating factors, circumstances that seem to make the crime worse. In Blakely versus Washington in 2004, the court reserved those determinations for the jury. So the jury gets to decide. As far as the Supreme Court is concerned, the juries get to decide how severe the crime was. And judges can increase that. In a handful of states, sentencing is determined by a jury. In cases involving the death penalty, jurors rather than judges decide the sentence. This is Ring versus Arizona in 2002. That's actually a picture of Mr. Ring. Okay. It was the jury that decided what his punishment was going to be. You see all these boxes underneath? That has to do with his trial. He was studying his own trial. Any defendant has the opportunity to appeal a verdict to a higher level of courts. Appeals are also possible in virtually every civil suit. And this is one of the reasons, remember I was telling you about well actually it was Bell Telephone at the time. I was telling you about the case against Bell Telephone. One of the reasons that they didn't pay off for like ever is because they kept appealing it to a higher court. And they strung this thing out for decades, literally for decades, before they decided. By that time, most of the people, a lot of the individuals that had sued them were soldiers. A lot of them went to Vietnam and died. They were killed in the war. So a lot of the individuals were no longer part of the suit. For an appeal, the appellate judges read the record, the transcript of the trial proceedings, the pleadings, the motions and accompanying documents filed by the attorneys, the briefs, written arguments from both sides about the issues on appeal, and then decide whether to overturn the original trial decision or to let it stand. Normally they will let it stand. Sometimes they will call for another trial. especially if one of the judges or one of the attorneys didn't disclose selected pieces of information. They also might decide that the defense attorneys didn't do a very good job of defending the individual that was convicted. Appellate judges rarely reverse a verdict on the basis of the facts of the case or the apparent legitimacy of that verdict. If you remember the Manafort case, if you guys were listening to the Manafort case, one of the things that was happening during the Manafort case was that the judge seemed to jump all over the prosecution. He never said anything negative about the defense lawyers, no matter what they said. But he seemed to jump all over the prosecuting attorneys. And the reason he did was because the case was so strong, he didn't want it to be thrown out on appeal. He wanted to make sure that this remained a strong case, because it was fairly obvious that Manafort broke a lot of laws and that he probably would be convicted. But he didn't want the prosecution to favor the prosecution, because if he favored the prosecution, then he might have it might have been thrown out on appeals in an appeal case. And of course, it is being appealed. But before and I think it's already been heard. If I'm not mistaken, it's already been heard. It has already gone to the appellate court. And that's one of the reasons, if you remember, Manafort was kind of biding his time, trying to decide whether he was going to testify against the president, I guess. He was going to give information to the Mueller case. He swore that he never would. He would never give any information to the Mueller probe, but he lost in appeals, so now he's giving information to the Mueller probe. The way this thing works. When they do reverse, it is usually because they believe that the trial judge made a procedural error, such as allowing controversial evidence to be presented. And usually that's the reason that they throw something out, because evidence that shouldn't have been presented, or something that one of the lawyers said. And for that reason, the prosecuting attorneys are very, very careful about what they say in court. The defense attorneys are trying to throw out all of these strange ideas. And usually, of course, it is the prosecuting attorney answering the defense attorney that gets thrown out. This is the evidence that usually gets thrown out. If a verdict in a criminal trial is overturned or reversed, the appeals court will either order a retrial or order the charges thrown out. In civil cases, an appellate court can let the decision stand. They can reverse it, rule in favor of the side that lost, or make some other charges or changes in the decision and return the case to a lower court for reconsideration. And that is an appellate court. These are appellate judges. A lot of times, 3 of the judges will look at the case, and if 2 of them decide that it should be thrown out, then it will be thrown out. That's usually the way it works. One of the interesting things that is going on with this administration has been intact for 2 years now. One of the things that's happening is that they are appointing a lot of judges to the lower courts. And actually, they've appointed 2 Supreme Court justices, but they're appointing a lot of judges to the lower courts. And for that reason, most of these judges are relatively conservative. So that's going to change the way that we see that the courts make decisions in the future, because these are lower court judges, and so they see most of the cases. Not the Supreme Court very rarely sees a case. It only sees the cases that it chooses to accept. But the lower courts, of course, they see a lot more cases. So if we have more conservative judges in the lower courts, we're going to get a lot more conservative decisions in the lower courts as well. So that's one of the things that has happened with this administration. He may not be filling all of his cabinet posts very readily, but he is appointing a lot of conservative judges. Video conferencing that permits live two-way video and audio communication. This is what the courtroom of the future is going to look like. Video conferencing that permits two-way video and audio communication. Electronic and digital evidence. And we're already seeing that in tweets and other electronic information. Well, how do you guys feel about this? So we've got these people that are tweet. Well, Donald Trump says really strange things. He called somebody horseface the other day. Stormy Daniels, the stripper or the adult video star. He called her horseface the other day. So how do you feel about that? I mean, how important is that? If I get pissed off and I start swearing on the internet, of course they'll probably kick me off. But don't they? I mean, if you use the F word too much. Yeah. Oh, you get thrown out? Or?
Yeah, it usually, I mean, you can pretty much go as far as you want to take it on the internet, but no action will be taken unless somebody that's bothered enough to report it to get you blocked or kicked off.
Oh, okay. That happened to my wife's cousin. He's real conservative. I mean, so conservative, he's almost a Nazi. He's that bad. His handle was Cro-Magnon Man, which doesn't seem that controversial, but they made him change his avatar. So he's not Cro-Magnon Man anymore, he's something else. I don't remember what. But my wife keeps blocking him because he keeps throwing up all this really stupid stuff. Anyway, so can you say, somebody has to complain, is that what has to happen?
Yeah. Someone has to get bothered enough to report you.
To Google or, not
No,
Google, to
there's an
Facebook?
option. Yeah, on any media, I believe, even on Snapchat or on Instagram or on Twitter, and especially Facebook, I'm more familiar with.
Right.
On there, if you are bothered by a content, you have rights on there, I guess, to go ahead and block it, just so you don't see it, so it doesn't come into your feeds. But if you do continue to see it come up through other people's feeds, then you can report it.
Okay.
And they usually do get kicked off of Facebook for a while.
Doesn't Snapchat go away after like 15 minutes or something?
Yeah.
But you can take a screenshot of it, I guess, to prove that it was there.
And then you do get reported for taking a screenshot. So the person knows that you are taking screenshots of it. So even they have the right to report you if they don't like the word, they don't like you taking it.
So what happens on Twitter, isn't that what it is? Twitter? Right? Okay. Is that Donald Trump will say something and he'll misspell half of his word. And then the media gets a hold of it, and then the media keeps reproducing what he says. Okay. But then he'll take it off. He'll take it down and claim that it didn't exist. But of course, people have a copy of it. Is that okay? Is it okay to copy something on Twitter?
It's like a sidewalk.
Public domain, just like a sidewalk. Okay. So, but Snapchat, you can't take a screenshot of something on Snapchat. Can you?
It will be reported though. Like the person will know someone's taking it. Like if I were to put something on Snapchat and someone sees it and they take a shot of it from their phone, then
Right.
it'll let me know so-and-so went and took a screenshot of this
Okay. And then you can complain and get them.
if you want.
Okay. All right.
But then pretty much there is like disclaimers in there that will tell you, I don't know how many people read the disclaimers because they're
Right.
like that long.
Sure.
But I usually pick and choose what I want to know from that.
So if I take a screenshot of a Snapchat,
And the person will know.
then the person knows. I have to know in order for me to put something, let's say that I'm trying to get you in trouble. So I pretend that I'm you, but that doesn't work that way, does it? Because it has an identifier, right?
Yeah.
And I can't
Yeah.
identify myself as you. Okay.
But you can be somebody else.
I can be Cro-Magnon. Okay, so electronic and digital evidence is something brand new. If you remember the Manafort case, the judge in the case didn't use email. And everybody was going, oh my goodness gracious, he doesn't use email. And most of the evidence was electronic. It was electronic tax forms and disclosure forms and whatnot. Computer animations and simulations are something for the future. Virtual environment technologies that allow observers to experience a recreation of an event as if they were actually present when it occurred. And of course, this is becoming more and more sophisticated. Potentially in the future, we will be able to use 3D objects. Wait a minute, what do they call it? Holograms. They'll be able to use holograms. So we'll actually be able to watch a recreation of the crime. I know. Will that be admissible in a court of law?
I don't know, but it's gonna stir up a lot more emotions than not, I guess, for the people in the courtroom.
Yeah, you would think
That
it
rather
would.
would not have a reaction, emotional reaction just to the hearsay,
Exactly.
but to actually see it unfold in front of you, I don't know, that'd be interesting to see how that all plays out for the defender and the.
I'm guessing that they will try to get that blocked. They will try to block anything like the hologram evidence. And of course, the judge will have to, they're going to have to make a decision on this at some point. I keep claiming that, and I may be correct or I may be incorrect, but I keep claiming that if they legalize marijuana in the United States, people are going to get dumber and dumber and dumber. And this is a movie called Idiocracy, one of my favorite movies.
I love that movie.
Anyway, this is when he goes to court, I think, or maybe not.
Welcome, that's good. I love you. My daughter says every time we walk into any big department store or stores.
So this is the trial scene.
Joe was arrested for not paying his hospital bill and not having his UPC tattoo. He would soon discover that in the future, justice was not only blind, but had become rather retarded as well.
I'm fixing to commensurate this trial here. We gon' see if we can come up with a verdict up in here. Now, since y'all say you ain't got no money, we have proprietarily obtained for you one of them court-appointed lawyers. So put your hands together and give it up for Rico Pendejo.
You're my lawyer?
Says here you, robbed the hospital? Why'd you do that?
Yeah, I'm not guilty.
That's not what the other lawyer said.
Listen, try to get me on the stand, okay? I can explain everything. We can take him to your house. We'll show him the pocket I came in.
Shut up! Prosecutor, why you think you done it?
Okay, number one, Your Honor. Just look at him.
It talks like a fag, too.
We've got all this, evidence of how, this guy didn't even pay at the hospital. And I heard that he doesn't even have his tattoo. I know, and I'm off. You gotta be shitting me. But check this out, man. The judge should be like, guilty. Peace.
Jackson!
What are you objectifying on?
Come on, just get me on the stand.
Your Honor, I object that this guy also broke my apartment to shit. Yeah. And you know what else? I object that he's not gonna have any money to pay me after he pays back all the money he stole from the hospital.
Don't say I stole. You're my lawyer.
And I object that he interrupted me while I was watching Oh My Balls! That is not okay! And I rest my case!
Your Honor, I'm pretty sure
sure we have a mistrial here, sir.
I'm gonna mistrial my foot up your ass, you don't shut up.
Please listen. I didn't steal anything. I was part of an army
Joe
experience.
stated his case logically and passionately, but his perceived effeminate voice only drew big gales of stupid laughter. Without adequate legal representation, Joe was given a stiff sentence. Meanwhile,
That's it. Okay. Well, anyway. Yeah. Maybe what our next criminal justice system looks like.
1 million views.
If we get dumber and dumber and dumber. Oops, and that's the end of that chapter. Okay, well, that's not bad. What chapter was it? 8? This is the 10th week, and I'm just a little bit behind. What's the next chapter about? Next chapter, that's not right. Yeah, chapter 9, alternatives to traditional prosecution. I'm not gonna start a new chapter. I have to go downstairs anyway. So class is over with. Thank you. We'll start chapter 9 on Wednesday. I know.